My calendar says quarterly review. That's the entry I created 3 weeks ago when my assistant asked what to block Thursday afternoon for. Quarterly review. Standard language for the kind of meeting we've held 4 times a year for 9 years. Numbers, projections, vendor updates, compliance status. The meeting where I present and my parents sit at the head of the table and nod and occasionally ask questions. I walk into the conference room at 2 in the afternoon with my laptop and a folder of reports I've been preparing since Monday. There is champagne. Not in a corner, not on a side table, not being discreetly prepared for after the meeting. Champagne, open. Being poured. Glasses in people's hands. The specific sound of a celebration already in progress. There is a screen at the front of the room. The screen that usually shows my quarterly slides. It reads, "Deal closed." My father is standing near the window. He has his glass up. He's mid-toast. He sees me come in and his expression does something, a small recalibration so fast I almost miss it. And then he smiles the full smile he saves for rooms that are watching him. "Kali?" He opens his arms slightly. "We finalized the $750 million sale. Congrats, sweetheart." The room turns. 20-some people. Staff, executives, lawyers I don't recognize in suits that cost what some people's cars cost. They turn and look at me the way you look at someone who has just been welcomed into something. I look at the screen, I look at the champagne, I look at my father's face. Then I look at the table. There's a closing binder being passed around, multiple signature pages. I look for my name. My name is Callie Whitaker. I am 48 years old. I've been the operational spine of Whitaker Group for 19 years. Not the face. That was always my parents, my father at the podium, my mother beside him. The two of them filling rooms with the comfortable authority of people who have always believed they belong in any room. I was the one in the back office, in the compliance meetings and the vendor renegotiations and the audit prep and the years when the company was bleeding and someone had to make the decisions that nobody wanted credit for because they were difficult and quiet and nobody was watching. During the bad years, 2011 through 2015, 4 years of genuine crisis, I rewrote 3 vendor contracts that saved us $11 million. I restructured the operations workflow that cut our carrying costs by 1/3. I built the compliance framework from scratch when our old one was flagged in an industry review. The buyer I know trusted this company because of what I built, the operational systems, the clean audit record, the frameworks that made us acquirable at premium valuation. I am looking at a closing binder that represents the culmination of 19 years of my work. My name is not on the signature page. The binder goes from my father's lawyer to a staff member to an executive I don't recognize, and I watch it move around the room, and my name is not anywhere on the signature page. And I understand, in the specific way you understand something you've been not wanting to understand for a while, that this was planned. My mother appears beside me. She puts her hand on my arm. She leans close and says, quietly, close enough that her voice doesn't carry, "Don't embarrass us. Just smile." I smile. I hold the smile for the full duration of the celebration. I accept a glass of champagne. I speak to people I know and people I don't. I shake hands with the lawyers in the expensive suits, and I say the right things in the right tone, and I give my parents exactly what they asked for. I smile. I drive home. Luke is in the kitchen. He asks how the quarterly review went, and something about the way I say fine makes him look at me more carefully. I tell him what happened. Not all of it. The pieces I understand. The champagne, the screen, the binder without my name. He listens with the face of a man who wants to be helpful and isn't sure how. "Maybe it's not personal," he says. "Maybe they're protecting you from liability." Protecting me from the company I've been running operationally for 19 years. "Like you're fragile," he says, and then hears it and stops. "No, not fragile. I just mean, maybe there's a reason they haven't explained yet." I don't argue. I go to my laptop. There's an email from the acquiring firm's communications office, a welcome message sent to key company contacts. "Great meeting you, Mr. and Mrs. Whitaker. We're excited to move forward." Mr. and Mrs. Whitaker, 2 people. My parents. The company I've operated for 19 years has just been introduced to its buyer, and I don't appear in the introduction. I am not even a name they're aware of. I close the laptop. I sit with that for a long moment. HR calls me Friday morning, not my HR department which reports to me. The corporate HR function, which operates above my reporting line and answers to the executive committee, which is my parents. The woman's name is Petra. She has a formal tone and the specific, careful cadence of someone delivering a message they've been told to deliver in a precise way. She says she's calling to clarify reporting structure following the transaction closing. I ask what specifically is being clarified. She says my title has been updated to reflect my role in the new organizational structure. I ask what my title is. Senior Advisor, she says. Not Chief Operating Officer. Not Vice President of Operations. Not any of the titles I've held and built into meaning over the course of my career. Senior Advisor, a title with no authority, no voting rights, no operational control, no access to the governance processes that determine company direction. When was this change made? I ask. She gives me a date and time. The same day as the closing celebration. The same hour. While champagne was being poured in the conference room and I was smiling because my mother asked me to, my title was being changed in the HR system to remove my authority. Who submitted the request? I ask. A pause. Brief but present. Your mother, Petra says. Sunday dinner at my parents' house has been a fixture of my adult life for as long as I can remember. My mother cooks. My father pours wine. We sit around the table that has held 30 years of family conversations, and I have always felt, at this table, that I knew where I stood. Tonight I understand that what I thought was standing was always just where they let me think I was. My father makes a comment midway through the main course. He says it the way people say things they want to land casually but have actually prepared. Callie's always been emotional about business, he says. He says it to Luke, but with the projection of someone speaking to the room. She cares deeply. It's a wonderful quality. My mother adds her part. Right on cue. She'll be happier with less responsibility. Some people thrive with more focus, not more scope. Less responsibility, happier with less. The framing of my removal as a kindness performed for my benefit. Luke studies his plate. I look at him. His fork moves. He doesn't look up. The conversation moves on. My father talks about the acquiring firm's team. My mother talks about an upcoming trip they're planning with some of the buyer's executives. I eat my dinner. Under the table, my phone buzzes. I check it discreetly. A message from Beth, who has been my closest friend since college and who worked in corporate law for 11 years before moving to a different industry. Callie, did you sign anything lately? Like any shareholder docs? I text Beth back from the car on the way home. No, I haven't signed any shareholder documents. I haven't signed anything related to the transaction at all. That's the entire point. I was not included in the transaction. She calls me immediately. Beth explains that her cousin works in corporate filings, not for my company, not for the acquiring firm, for the regulatory body that records certain transaction documents in the public record. Her cousin saw something. My name attached to a consent packet filed in connection with the Whitaker Group transaction. A consent of shareholders form. A document by which shareholders provide formal approval of a major transaction. My name is on it. A document I never saw, a consent I never gave. My name on a filing I have no memory of signing because I did not sign it. I sit in my car in my parents' driveway. Are you sure? I say. My cousin pulled it and read it twice, Beth says. Your name is there, Callie, full legal name, your signature in the signature block. Beth, I didn't sign anything. I know, she says. That's why I'm calling. I drive home. The next morning a courier arrives at my door. He's carrying a professional envelope, the kind used by law firms for formal communications. He asks for me by name. He asks me to confirm my identity. He hands me the envelope. For your records, he says. I open the envelope at the kitchen table while Luke is upstairs. It's a document package. Several pages, professionally prepared, carrying the letterhead of a firm I don't recognize but whose name I write down immediately. It is described as a family settlement agreement. It offers me a fixed payout. The number is not small in absolute terms. In the context of a $750 million transaction, it is not large. It is a fraction, a quiet fraction with a document built around it. The language is careful and legal and layered, but the substance underneath the layers is this. I accept a specific amount. I waive any claims related to the transaction. and I agree not to disrupt the sale or the operations of Whitaker Group going forward. Not disrupt. As if asking for what I'm owed is disruption. As if existing is something that requires management. I read through the pages. The language about my role is the particular language of someone who has been decided about. Not a partner, not a principal, not a co-owner whose consent is legally required. A nuisance. A manageable complication. Someone to be paid off cleanly and at a discount. I turn to the last page. There is an attachment listed, a document incorporated by reference into the settlement. Spousal acknowledgement attached. I read it again. Spousal acknowledgement. Luke's name in the referenced field. Luke has already seen this document. I go upstairs. Luke is in the home office. He's at his desk, and he has the look of a man who heard me come in and has been deciding what to say. I set the envelope on the desk in front of him. "When did you see this?" I say. He looks at it. He doesn't pick it up. "Your mom asked me to look at something," he says. "She said it was paperwork to make the transition cleaner." I glanced at it. "You glanced at a legal settlement document that waives my rights and you signed your name to a spousal acknowledgement." "I didn't really," he stops. "I didn't think it was a big deal." "You signed a document acknowledging that your wife agrees to a settlement she wasn't shown." He looks at the desk. "She said you'd be upset at first," he says. "She said once things settled down, you'd see it was for the best." She said, "My mother told my husband what I would feel, and he accepted her characterization of my future emotions as a substitute for asking me." "She said you'd calm down after," he says. I look at him. He's not a bad man. I've been married to him for 16 years, and he is not a bad man. He is a man who trusts the wrong people when they sound confident enough, and who has been offered a version of my emotions that was easier to accept than the version that required him to ask me directly. "Okay," I say. I pick up the envelope. I go back downstairs. I get my keys. I drive. I don't drive home. I drive to an office. Not a familiar office. A name I looked up 3 nights ago when I couldn't sleep and found myself searching terms I hadn't expected to be searching. Corporate attorney, shareholder rights, minority owner, closely held corporation. The attorney's name was at the top of 3 separate search results for different reasons, all of them suggesting she was the kind of person you wanted when a situation was both corporate and personal and required someone who understood both registers. I park. I go upstairs. I sit across from her desk. She introduces herself, Sienna. She has the quality of a person who processes information quickly and without visible reaction while processing it. She listens to what I say and takes notes and doesn't reassure me prematurely. I tell her about the conference room, the champagne, the binder, the title change, the settlement envelope, the spousal acknowledgement Luke signed. I tell her about Beth's call and the shareholder consent document with my name on it. Sienna listens. She takes notes. She asks 2 clarifying questions about timing. Then she looks at me. I say 1 sentence. "I think they closed a deal without the required approvals." She writes something down. Then she puts down her pen and looks at me with the focused expression of someone who has just identified the load-bearing question. "Do you own voting shares?" she says. "And do the company's bylaws require your consent for a transaction of this size?" I answer both questions yes. Not confidently, at first. Not with the certainty of someone who has been tracking this, with the uncertain yes of someone who knows something is true, but hasn't recently confirmed it. The shares came from my father. 12 years ago, during a period when the company was doing tax planning, and the advisor recommended distributing some equity to family members who were actively involved in operations. My father gave me shares. A specific class, a specific percentage. He explained it in the way he explained things he considered minor details. Briefly, without emphasis, the same tone he used for everything that was administratively necessary but didn't reflect the real distribution of power in his mind. The bylaws. When I came into the company formally, 19 years ago, I went through the operating documents carefully because that's what I do. I read things, I remember things. There is a provision, I remember it existing, a vote requirement for major transactions above a threshold. I don't remember the exact language, but I remember the provision. Sienna's eyes sharpen in a specific way. The way eyes sharpen when information moves from interesting to significant. She asks me to describe the shares. The class, the percentage, everything I remember. I describe what I know. She asks about the bylaws provision. I tell her what I remember. She writes for a full minute. Then she looks up. If both of those things are as you describe, she says carefully, then this sale may not be clean. She says it the way you say something when you want the words to carry exactly the weight they carry without any additional weight. Not clean. A $750 million transaction that may not be clean. I go home. I go to my study, and I go to the filing cabinet in the corner, and I open the bottom drawer. The drawer I haven't opened in years. The drawer I've thought of without thinking about it consciously as the boring drawer. Tax returns, old insurance documents, correspondence from the early years of my involvement in the company. And at the back, a file box, hanging folder. Label in my own handwriting from 12 years ago. Inside, stock certificates. The originals, not copies. The thick cream paper with the raised seal that represents the shares my father transferred to me. Board minutes from that period. Meeting records I was copied on as a shareholder. An operating agreement amendment from 10 years ago. And at the bottom, in a folder labeled Miscellaneous, Father. An email I printed. A habit I had then of printing important emails that I've since mostly abandoned, but that 12 years ago I maintained consistently. I read the printed email. My father's handwriting, no, his email, in the formal tone he used for things he wanted documented. Addressed to me. The subject line, Share Transfer, Callie. The body, confirming the share transfer, describing my rights as a voting shareholder, and containing one sentence I read 3 times before I understand what I'm looking at. Your vote is required for any sale of a controlling interest, per Section 7.4 of the operating agreement. And underneath that, one more sentence. No exceptions. The calls start the next morning. My mother is first. Her voice has the particular warmth of someone who has chosen warmth as their opening position because harder things are coming. She says she knows I've been processing. She says the settlement is generous. She says the family needs to move forward together. If you fight this, she says, and her voice doesn't actually drop, but something in the tone does, something goes from warm to firm without the temperature changing, you'll ruin the family. Everything we've built, the relationships, the legacy, the future. All of it. Do you understand what you'd be doing? I say I understand. She says good. She says she knew I'd come around. I hang up. My father's text arrives 11 minutes later. Don't be greedy, Callie. This is bigger than you. I write the time and the exact words in my notebook. Luke comes into the kitchen while I'm writing. He has coffee. He offers me the second cup and I take it. Have you thought more about the settlement? He says. I have an attorney, I say. He sets his cup down. Maybe take the payout. Maybe that's the cleaner path. It's not the right path. He's quiet for a moment. Then my father's second text arrives. And stop talking to lawyers. I photograph both texts. I add them to the folder Sienna asked me to build. The family meeting happens on a Saturday. I don't know it's a family meeting. I'm told by my sister-in-law that my parents want everyone for lunch. Casual. Come by around noon. I arrive at noon. There are 12 people in my parents' living room. Aunts, cousins, my father's brother, people I see at holidays. They have the assembled look of a group that arrived before me and has been talking before I got there. My mother greets me with a hug. Her hug is warm and firm, and she holds it slightly too long in the way that communicates something other than warmth. The conversation that follows is not a conversation exactly. It's a performance with a script only some of the participants have read. My father mentions stress. My mother mentions that I've been going through a difficult period. A cousin says something sympathetic. An aunt expresses concern. I listen to it. The structure of what they're doing is clear to me because Sienna described it on our second call. When the documentary approach fails, when the target won't accept the settlement and won't go quietly, you attack the narrator. You make the narrator unreliable. You seed concern in the community so that when the narrator speaks, the words land in a prepared context. You build a story. She's not well. She's not herself. She's struggling. I'm watching my family build this story in real time. My aunt finds me in the kitchen refilling my water glass. She puts a hand on my arm. She leans in with the tone of someone delivering a private warning. Your mom said you've been forgetting things, she says. Are you okay, really? The call from the acquiring firm comes on a Tuesday. A man named Parrish, an executive from the integration team. He calls my direct line. The one on my business card. The one that exists because I've been an officer of this company for 9 years, with a title that carries operational authority. He introduces himself warmly. He says he's been meaning to reach out. "We assumed you'd be thrilled about how everything came together," he says. "Your parents said you were stepping away for health reasons, so we didn't want to bother you during the transition." I sit at my desk with my pen stopped against my notebook. Stepping away. For health reasons. "I'm not stepping away for health reasons," I say. A pause. "Oh," he says, the pause of a man recalibrating. "I apologize for any miscommunication. We were told," he stops. "I'm sorry, I may have the wrong information." "You were told I was stepping away for health reasons," I say. "By my parents. I shouldn't have." He stops again. "I'm sorry, I don't want to create a problem." "I'm not stepping away," I say. "I'm the COO, or I was, until my title was changed without my knowledge during the closing." Another silence. "There's something else," he says, in the tone of someone deciding to share something he wasn't sure he was going to share. "There's an earn-out provision tied to your department's operational metrics." I ask Parrish to explain the earn-out. He explains it carefully. A portion of the $750 million significant contingent is tied to performance metrics measured over a 3-year period following the close. The metrics are operational, compliance rates, efficiency benchmarks, system performance indicators. The systems those metrics measure are the systems I built, the compliance framework I created from scratch during the crisis years, the operational dashboard I designed and implemented, the vendor management protocol I developed and still run. Without my involvement, without my knowledge of how these systems work and what they're measuring and how to maintain the standards they were built to achieve, the earn-out is at risk. My parents sold a company for $750 million, and part of that payment depends on the operational infrastructure I built continuing to perform, and they removed me from the company the day the deal closed. I call Sienna. She listens. She says, "Do not sabotage anything. Do not touch any system. Do not modify any record. Do not make any change that could be characterized as retaliatory. Do your job normally and at the highest standard. Document everything you do and everything you're not allowed to do." "I understand," I say. "Because the earn-out is leverage," she says, "but only if your hands are completely clean." "They are," I say. That night I try to access the compliance dashboard. The system I built, the login screen loads, and I enter my credentials. Access denied. IT responds to my access inquiry the next morning. The reset of my credentials was initiated by executive instruction. They won't specify further without a formal inquiry. The phrase they use is standard procedure following transition events. Transition event, the closing of a sale I wasn't consulted on or included in. My father calls while I'm reading the IT response. "I heard you tried to access the dashboard," he says. I don't ask how he heard. The answer is obvious. Someone flagged my login attempt and told him. "I need it for my work," I say. "You don't need to be involved in that anymore," he says. His voice is pleasant, the voice of a man who has won something and is being magnanimous about it. "See, it's already handled. You don't need to carry all that anymore." He says it like my access being removed is a gift, like having the infrastructure I built taken from me is relief from a burden I've been carrying. I call Sienna. She says, "Document the lockout. Date, time, what you tried to access, what happened, and what your father said." I do. "Lockouts after a contested sale look like retaliation," she says. "If your ownership rights were improperly excluded from the approval process, and then your access is revoked when you begin raising questions, that sequence tells a story." "What kind of story?" I ask. "The kind that courts find very interesting," she says. "We use that." Sienna receives the term sheet on a Thursday. She's obtained it through a lawful request route, the appropriate legal channel for a document relevant to a matter involving a shareholder whose consent is in question. The acquisition produces certain documents that become accessible through proper governance challenges. She calls me that afternoon. "I want to go through the structure with you," she says. "Because the headline number and the actual number are not the same thing." I go to her office. She walks me through the term sheet page by page. The headline is $750 million. That number is in the press release. That number is on the screen that greeted me with champagne when I walked into the conference room. But the $750 million is not a clean $750 million. A significant portion is contingent, performance-based. Earnouts tied to operational metrics over 3 years. Additionally, there are adjustment provisions, standard in transactions of this type, but meaningful in their cumulative effect, that reduce the true value delivered at close. The amount my parents actually received at closing is substantially less than $750 million. The amount they will receive in total, over the full earnout period, depends on performance metrics that were the responsibility of the person they removed from the company. The earnout, I say. Yes, Sienna says, and the person responsible for the systems those metrics measure was supposed to be me, I say. Is supposed to be you, she says, present tense, because you still own shares, you still have governance rights, and the company still needs what you built. She sets the term sheet down. They locked out the very person the deal depends on, she says. Sienna files the formal notice the following Monday. It's not a lawsuit, not initially. It's a governance challenge. A formal notice to the company and the acquiring firm disputing the validity of the shareholder approvals on the grounds that a voting shareholder's consent was neither obtained nor properly waived. It includes a request for an injunction, not to stop the transaction, not to destroy what's been built, but to pause the transfer of certain contingent elements until the court can confirm that the governance process was properly followed. The distinction matters. We are not attacking the deal. We are requiring that the deal follow the rules that govern it. Sienna explains this to me carefully. Your behavior is the other half of the case, she says. You work normally. You cooperate with the transition. You do nothing that gives them material for a counter-narrative. You are the most professional person in this situation. I go to work. I cooperate with the integration team. I document everything I do. I am spotlessly, boringly professional. My father calls the day the filing is served. His voice is not the magnanimous voice of someone who has won. His voice has no performance left in it. You're choosing war, he says. I think about what Sienna told me. I think about the compliance framework I built in 2012 when the company was audited and everyone was panicking. I think about the vendor renegotiations in 2013. I think about 19 years of work that built the value they sold. I'm choosing what I'm owed, I say. I hang up. The mediation preparation session is at Sienna's office. Both sides are there, my parents and their attorney, Sienna and me. The purpose is to establish whether a pre-hearing resolution is possible before the formal governance challenge proceeds. Standard process. Both sides state their positions, identify areas of potential agreement, and determine whether there's a basis for settlement. My mother is in the chair across the table. She has the composed presentation she brings to formal settings. Controlled, measured, the expression of someone who has decided how this conversation should go and is maintaining that decision through force of will. She begins explaining their position. Then she says it. In the middle of a sentence about the urgency of the transaction timeline and the complexity of shareholder logistics, she says, "We had to sign for you because you'd overthink it." Sienna's pen stops. The room goes quiet, in the specific way rooms go quiet when something irreversible has been said. Sienna's voice when she speaks is completely level, completely professional. The voice of someone who has been waiting for exactly this moment and has no intention of making noise about it. "Did you just state," she says, "that someone signed your daughter's name to a shareholder consent document because you anticipated she would not agree?" My mother's expression changes. The composure recalibrates. She starts a sentence to clarify. She says something intended to soften it. What she says instead gives Sienna a second quote to add to the first. My mother's attorney puts a hand on her arm. It's too late. A special board meeting is called. My parents expect it to be a formality. A quick procedural vote to confirm the sale and establish the post-transition governance structure. The kind of meeting that exists to create a record rather than to make decisions. Sienna requested the meeting as part of the governance challenge, and the company's independent board members, the two who are not my parents, are required to attend. I'm there. My parents are there. Sienna presents to the board. She presents the operating agreement. Section 7.4. The voting requirement for transactions above a threshold. My shares. The class. The percentage. The voting rights attached to each share. She presents the shareholder consent document, the one filed with my name on it, and the evidence that I did not sign it. She presents the lockout timeline. My access removed the same day as closing. She presents the earn-out structure, and the dependency on the operational systems I built, and the operational metrics those systems are designed to deliver. She presents it all without drama. Just documents. Just dates. Just what happened and in what order. The room is quiet in the way large rooms go quiet when the air has changed. One of the independent board members, a man in his 60s named Fitch, who has been on the board for 7 years and who I have always thought of as a careful person, looks at my father. He says, in the measured tone of someone who has decided to ask the question directly, rather than allow it to go unasked. Why didn't you tell us Callie's vote was required? My father doesn't answer immediately. He looks at my mother, she looks at the table. The formal proceeding comes 3 weeks later. Under oath is different from across a conference table. Under oath is the moment when the version of events that was maintained through social pressure and family authority has to hold up against a standard it wasn't designed for. Luke is asked about the spousal acknowledgement. He's been prepared by his own counsel, a man he hired after I explained to him, quietly without anger, because anger wasn't useful, the position he'd been placed in. He understands now what he signed. He understands what he was asked to do and who asked him. He tells the truth. He explains what my mother asked him, the document she put in front of him, the words she used, routine, just paperwork. Callie will understand it's for the good of the family. He explains that he signed without reading because the person asking was his mother-in-law and he trusted her representation. He says, clearly on record, she told me it was routine. I didn't know what I was signing. He says it with the shame of a man who has understood what his trust enabled. Sienna, in her brief response, says, that is not consent, that is manipulation. A spousal acknowledgement signed by someone who was told the underlying document was something other than what it was, has no legal validity. She says it the way you say something when you want the words to land in the record without ornamentation. The judge writes. Parrish calls Sienna directly. He represents the acquiring firm's concern, which is now considerable. He is professional and controlled and very clear. The acquiring firm was told Callie Whitaker was stepping away for health reasons. They were not told she was a voting shareholder whose consent was required for the transaction. They were not told her approval was being handled through a document they've now been informed was not properly obtained. They were not told that the earn-out metrics they're counting on are tied to the operational systems of a person who has been locked out of those systems. They are not happy. My father issues a statement to the press, not a formal legal document, not a court filing, a statement to industry publications that covers the governance challenge. The statement characterizes me as having a personal dispute with the company's direction. It says, internal family dynamics have created complications. It uses the word unstable. Parrish's attorney responds on record. The filing states, the acquiring entity notes for the record that it has never been introduced to Callie Whitaker. Communications from the selling parties characterized Ms. Whitaker as absent due to health reasons. The acquiring entity received no information suggesting Ms. Whitaker was a required party to the approval process and was actively misled on this point. Then one line, direct and devastating. We never met Callie Whitaker. Why were we told she was ill? Sienna finds it through the discovery process. It's in the related party agreements, the documents that govern side arrangements between principals and associated entities in a transaction, not the main deal documents. The side documents. The ones that govern what happens to certain payments and rights when the main transaction closes. What she finds is this. My mother controls an entity, a management company, structured separately from Whitaker Group. This entity had an agreement with the acquiring firm, a consulting arrangement, executed as part of the broader transaction. The consulting arrangement triggered a payment to my mother's entity upon closing. The payment triggers only if the shareholder approval for the transaction is presented as complete, without triggering further governance review. If I had been properly included, if my vote had been sought, if the transaction had proceeded through the governance process that Section 7.4 requires, the consulting arrangement would have been subject to disclosure and review as a related party transaction. My mother's entity would have been scrutinized. The payment might not have been approved. They weren't just cutting me out of the deal. They structured the deal so that cutting me out produced a financial benefit to my mother that proper governance would have prevented. They weren't just excluding me. They were using my exclusion to move money to a place I couldn't see. The judge orders full disclosure of all related party agreements. The settlement offer arrives on a Friday afternoon, a new one. Not the thin envelope with the quiet fraction. A document with substantially larger numbers, a role, not senior advisor, an actual role with authority and operational scope. Language about family harmony and moving forward together. It's everything they refused to offer before the legal process began. I read it at Sienna's office. They're scared, I say. Yes, she says. Is this remorse? No, she says. Remorse looks different. This is panic. Panic looks like offering what you should have offered at the beginning when refusing it is no longer safe. I sit with the document. There's a part of me that wants to take it. Not because it's enough, because it would stop. Because I am 48 years old, and I have been fighting my parents in a conference room and a courtroom and my own kitchen for months, and I am tired in a way that goes deeper than sleep can fix. I look at Sienna. What happens if we settle now? I say. You get the number, she says. The court sees a private resolution. Everything that's been discovered stays in the settlement agreement and not in the public record. And the related party payments? Settled. Acknowledged privately. Never fully examined. I set the document down. We don't settle until the court sees everything, I say. The court rules 3 weeks later. The ruling is not dramatic in its delivery. It's a legal document, dry and precise, delivered by a judge who has reviewed thousands of pages of documentation and reduced it to findings of fact and conclusions of law. The findings are these. The shareholder approval presented in connection with the Whitaker Group transaction was improperly obtained. The signature attributed to Callie Whitaker on the consent of shareholders was not authenticated and cannot be shown to have been executed by the named party. The spousal acknowledgement signed by Luke, Callie's spouse, was obtained through material misrepresentation about the nature of the underlying document and carries no legal weight. Section 7.4 of the operating agreement required Callie Whitaker's affirmative vote as a holder of voting shares. This requirement was not satisfied. The transaction is not voided. It is subject to corrective governance. All parties must return to the approval process with complete and accurate information, with Callie Whitaker's participation as a required voting shareholder. The related party consulting arrangement is referred for scrutiny as an undisclosed conflict in the transaction approval process. The parties are ordered to renegotiate any term that was contingent on an approval process now found to be incomplete. My father's counsel files a motion to stay the order pending appeal. The motion is denied. The acquiring firm, when approached about corrective governance, elects to proceed. They want the deal. They wanted a clean deal. They can have one now. I sit at the renegotiation table. Not senior advisor. Not the person whose name was missing from the signature page. Not the woman who was told to smile while they finalized $750 million without her. I sit at the table with my attorney and my documents and 19 years of operational history that built the value everyone is here to divide. My parents sit across from me. My father looks older than he did the day I walked into the conference room and found champagne. My mother looks at the table the way Luke looked at his plate at Sunday dinner. Finding something to focus on that isn't the thing that matters. Luke is not at the table. He is in his own process, with his own attorney, understanding his own role in what happened and what accountability looks like for someone who signed something without reading it, because someone he trusted told him it was fine. The earn-out metrics will be met. I know this because I built the systems they measure. I know where the risk is and how to manage it. The acquiring firm knows this too, which is why they're at the table with the posture of people who have decided that the person across from them is someone they want to have working with them rather than against them. My mother's related party arrangement is voided pending review. The payment her entity was structured to receive upon clean closing without my involvement will not be released until the conflict of interest question is resolved. It may not be released at all. I don't feel triumphant sitting at this table. I feel something more precise than that. I feel like someone who did the work for 19 years, who was told to stay quiet and smile and accept what was offered, who decided that the quiet they were asking for was not peace, but erasure, and who refused. My legitimacy was always real. My shares were always real. My vote was always required. They knew all of it and built around it anyway and assumed the building would hold. The paperwork was always there. I just needed to open the right drawer. If your family ever tells you to stay quiet for the good of everyone, subscribe. Because silence is how they steal your seat at the table. And once you know what you're owed, the paperwork will always be there to prove it.